Hello and welcome back to the Center for Critical and Cultural Theory. My name is Dr. Roger Green. This is a continuing lecture video on, or contextualized reading, as I like to call them, on Jacques Derrida's famous essay, Force of Law. I've been taking this very, very slowly, and I will continue to do so here as I share my screen. This is an ongoing course that on Intro to Critical Theory, but of course you can tell by the depth that I'm going into these final readings, this, and then we'll do Giorgio Agamben after this. Uh, I'm really trying to take things slow, and I'm trying to address some places in culture where these thinkers and their works are showing up, and I'm very well aware of a heightened sense of criticism lately around postmodern thinkers. It could be Michel Foucault, it could be Jacques Derrida, it could be all sorts of different thinkers associated with post-structuralism or postmodernism. And there is something in the nature of thinkers coming in and out of fashion or being canceled at different times. And I'm trying to resist the kind of cancel culture that exists out there, and not necessarily like rescue Derrida, but definitely to say that it's too easy to write somebody off, or an entire group of thinkers like the postmodernists off, as being some sort of scapegoat for the crappy conditions that we might have in the world today. So in the last lecture video, we were about page 15 in Derrida's text here of Force of Law, and he had been talking about the fact that deconstruction is justice, but justice is also deconstructible, and so that this kind of aporia, this kind of puzzle that appears when we try to think about and talk about justice, and justice being here distinct from something like law. So just to recap where we were, what he was saying. He says, in other words, the hypothesis and the propositions toward which I'm tentatively moving here call more for the subtitle Justice as the Possibility of Deconstruction, the Structure of Law, droit, or the law, the foundation or the self-authorization of law as the possibility of the exercise of deconstruction. I'm sure this isn't altogether clear. I hope, though I'm not sure of it, that it will become a little clearer in a moment. So this is where we were in the previous contextualized reading lecture. As we move on here, we want to remember that Derrida completely recycles. He's the whole opening of this essay and throughout the whole thing, he keeps drawing our attention to the context of the speaking moment in which he is addressing uh, this audience of legal thinkers in the United States, the fact that he's addressing them in English instead of French, and the challenges that accompany that linguistic um, uh, uh, um, uh, translation process. I think another theme here throughout the essay and in my earlier contextualized readings is that notion of the idiom, right? Not just the, you know, denotative meanings of a sentence in a particular language, and it's the difficulty of translating that, but the difficulty of translating idiomatic phrases, right? And so that's going to be really important in some of the paragraphs that follow here. So as he goes on page 15 of his text, I've said then that I've not yet begun. Perhaps I'll never begin, and perhaps this colloquium will have to do without a quote keynote, except that I've already begun. I authorize myself, but by what right? to multiply protocols and detours. Now, this is the kind of language that is maddening to people who are outside, who don't haven't been paying attention to post-structuralism. It seems like mental gymnastics, or it seems very, very egocentric, self-referential, and it seems like we never get to where we want, just like, why can't you just be clear about what you're saying? And I want to say that this is very much part of Derrida's intention, is to be disruptive, to give us a kind of politics of pause, if you will, to resist that kind of politics of acceleration, where we would go straight to the heart of the matter. And that's not to say that he's not taking this situation very seriously. I think he's saying that if we really want to take justice seriously, we're going to have to come at it, as he will say a little bit later, obliquely. We're not going to be able to go directly at it. So he says, "I've said then, I haven't begun, but I have begun." And then he's talked about authorization of himself. And in previous lectures, and also just out in the world of post-structuralism, we have famous essays by Roland Barthes and The Death of the Author and Michel Foucault. What is an author? Where Foucault talks about the author function. We talk about the idea of an author as somebody who historically, as Foucault says, comes about with the ideas of modern subjectivity and modern philosophy, but is also the subject who is going to be held accountable potentially for the things that they say. Or the artist is, well, this at the same time we get this artist as a kind of genius figure who's signing the name on works. We're also getting a legal structure that will prosecute people for heresy in Spanish Inquisition or something like that. So authority is a itself a really broad concept with a lot of nuance in this essay. And he says he's authorized himself. He says, I began by saying that I was in love with at least two of your idioms in English. One was the word enforceability. The other was the transitive use of the verb to address. Remember from earlier contextualized readings. In English, we have transitive verbs. Um, uh, um, uh, or so what is an example of um, I am addressing you, the addressing, and if we take well, let me take an intransitive verb like the sun shines. We can say the sun shines on me and make it transitive, right? But we can have it as just the sun shines. We can have I speak to you, my audience, or I can just have I speak, right? In the sentence I speak, the speak is um, acting intransitively. Uh, when we say the verb to be, I am Roger, that verb acts as a kind of axial point between subject Roger and object, or sorry, subject I and object Roger, right? When I mix up the words am I Roger and I put the verb first, then I create a question in English syntax. If I put Roger first, to say Roger am I, then I start sounding like Yoda in Star Wars or something like that. Uh, so English after the French invasion, as I covered in an earlier talk, takes on a rigid syntactical structure and moves away from inflection. And French is still an inflected language. And so it's not that we have it completely gone in English, but that they have it very highly in French. To learn French today, you need to understand how inflection works. And we could say, I could say, in the Bible, it's translated like Yahweh's language is I am that I am, or just I am. That would be a kind of intransitive kind of sense. But usually in English, it would be like something like the way that the be verb is used, and especially in African American vernacular uses of the language, like I be. Um, I be speaking, for example. I am always speaking. That kind of context that in sort of mainstream or conventional or edited academic Englishes, as we might call them, we have a reduced use of verb structure, whereas African American vernacular has more tense availability to it. Just an interesting aside there. Um, and I do think that it's like that the more I think about African American vernacular and where some of this comes from, it very much comes from the not just the South, but particularly from New Orleans, because that was such a big part of the slave trade and because it was controlled by the French. And so we get another kind of immersion of or of French and English in that particular part, that geography of what is now the United States, and so African American vernacular English, I think carries on some of the possibilities, and develops, of course, its own through intermixing not only of African languages and English, but the French as well. So as he goes on here, he's going to talk about the French and the difference between French and English. He says, I began by saying that I was in love with those two idioms, enforceability and to address, the transitive use of to address someone. Um, uh, in French, one addresses oneself to someone. Um, uh, One addresses a letter or a word, also a transitive use, without being sure that they will arrive at their destination, but one does not address a problem. So still less does one address someone. So again, if you're not a French speaker, you've never studied French, this is important. Here's what he says. In French, one addresses oneself to oneself, to someone. One does, I wouldn't say I am addressing you. You would say, like, to translate into English, I am addressing myself to you. And if you look up the verb forms of address, or try to find to address in a French dictionary, you will get the noun versions of address, like an address, like a number that I write on a postcard to send to a particular location, or an address that I gave last night, like a speech that I gave last night. But whenever we won't move into the verbal notions of it, if it said I'm giving an address, that it would be translated like I'm giving an allocution, or there's so it'll be a substitute type of word in French. Uh, or I am giving a lecture, right? The way that lecture becomes a noun in that sense. So uh, in French, one addresses oneself to someone. One addresses a letter or a word, also transitive use, without being sure that they will arrive on a destination. I write the address on an envelope and I put it in the mailbox, and maybe it will arrive. I hope that it will arrive. But Derrida has a lot to say about that in a whole book about postcards. Um, so he goes on to say, tonight I've agreed by contract to address. So there's, and that contract, that's a very important word here in this context. I've agreed by contract to address in English a problem that is to go straight toward it and straight toward you, thematically and without detour, in addressing myself to you in your language, between law or right, the rectitude of address, direction, and uprightness. We should be able to find a direct line of communication and to find ourselves on the right track. Now, again, that's exactly, he's making this distinction between English, which sometimes wants to be super direct, and uh, French, which wants to say, let's say, I address myself to you. There's a bit more space, and there might be a little bit of ability to float around a topic. Um, uh, he goes on, he says, why does deconstruction have, excuse me, let me just go one sentence behind it. Between law or right, the rectitude of address, direction, and uprightness, we should be able to find a direct line of communication to find ourselves on the right track. That's what lawyers generally want. Let's just be clear. Let's just have the facts, right? But and deconstruction um, uh, as it's been Derrida's project does not do that. So goes on and he says, um, why does deconstruction have the reputation, justified or not, of treating things obliquely, indirectly, or without quote with quotation marks, and always asking whether things arrive at the indicated address? Is this reputation deserved? And deserved or not, how does one explain it? And so we have already, in the fact that I speak another's language and break with my own, in the fact that I give myself up to the other, a singular mixture of force. Um, justesse and justice, um, a singular mixture of force. That's just an interesting phrasing there. Remember, as I've said in earlier contextualized readings, there's a bunch of Emmanuel Levinas hovering behind Derrida here. And all of Derrida's work, Levinas is hovering behind him. And so this giving myself up to the other, sometimes Levinas in his ethical statements will say, I am hostage to the other. There is something that Jacques Derrida has agreed to in the contract of coming to this event to speak and give the keynote, that is putting him in a situation of authority, but he has to authorize himself. And then at the same time, where he's obliged to say something, right? To say something concrete, even perhaps about justice, about the possibility of justice, or deconstruction and the possibility of justice, which is the name of the conference that he's addressing. And so he says, and I'm obliged, it is an obligation to address in English, as you say in your language, infinite problems, infinite in their number, infinite in their history, infinite in their structure, covered by the title Deconstruction, the Possibility of Justice. But we already know that these problems are not infinite simply because they are infinitely numerous, nor because they are rooted in the infinity of memories and cultures, religious or philosophical, juridical, and so forth, that we shall never master. They are infinite, if we may say so, in themselves, because they require the very experience of the aporia, the puzzle, right? That is not unrelated to what I just called the mystical. We covered that in an earlier contextualized reading lecture. He's bringing in the mystical element to not only the language and discussion around deconstruction, but also around law itself. And that's going to resonate with so many other people that we've read in this introductory course, going back to Carl Schmitt, the idea of political theology and the idea of law, and all significant political concepts being originally theological concepts in Schmittian terms, right? Sorry, Derrida here only addresses Schmitt obliquely, but want to contextualize it to see that that's the arc of this 20th century discourse that we've been going for in this critical theory course. It's going to continue on into Agamben after we get done with this Derrida essay. So as he continues on here, he's brought in the mystical, and that I think that that's one of the reasons why Derrida is still is important to this dialogue. Just the fact that he has brought that in, because it informs major thinkers right now, like Agamben and his project of Homo Sacer, for example. So he goes on, he says, when I say that they require the very experience of aporia, I mean two things. Now, aporia that language is going to take us back to Socrates, back to getting to that moment of not knowing, that through dialectic, we get to that kind of a point of ineffability. We move from a state of knowing to knowing that we don't know, right? Uh, and so again, yes, like people want to contextualized postmodern thinkers, or Derrida as a postmodern thinker, as bringing in everything's relative or something like that. And when we look at his actual work, he's doing a deep dive into not only Western civilization and Western culture, but all the way back to the Greeks. And he's addressing a whole lot of stuff. He's a really learned guy. And so just writing him off like with one phrase isn't useful. Um, or as I said at the end of my last contextualized reading, it's not useful to just write off the Enlightenment either, right? And I'm talking about Susan Neiman's book, which I agree with in some ways and disagree with in others. So we go on here. He says, when I say that they require the very experience of aporia, I mean two things. So first, uh, as its name indicates, an experience is a traversal, something that traverses and travels towards a destination for which it finds the appropriate passage. Notice how he's been talking about transitive verbs and transitive verbal experiences. Or well, transitive, like, and he's shifting that to the language of experience. I experience something. I am conscious, or consciousness is always consciousness. Consciousness is always conscious of a particular object or a particular thing, right? He's doing it's subtle the way he's talking about doing this in language, but he's talking about modern philosophy, and he's weighing that against ancient philosophy, the language of aporia, the language of Socrates, and then the language of, although his name has not been invoked, of a thinker like Descartes, or Pascal. They're different thinkers that have been making their appearances. Montaigne, for example, in an earlier part of this essay. And so when we're thinking about experience here, he says, the experience finds its way, its passage, it is possible. And in this sense, it is impossible to have a full experience of aporia, that is, of something that does not allow passage. Justice does not allow passage if it's undeconstructible, right? And so he says an aporia is a non-road. From this point of view, justice would be the experience that we are not able to experience. We shall soon encounter more than one aporia um, that we shall not be able to pass. So that's one of the things. On the one hand, when we're talking about law, when we're talking about justice being done, once we particularize that into the instance of justice have been being done in this particular context, it localizes it, and it is no longer the form of justice that we are thinking about when we're thinking about it as a kind of concept, right? And this is very Platonic in the way that Derrida is thinking about this, the idea of justice, and it does go back to Socrates for sure. Um, uh, uh, so that's point one. Point two here is, but I think that there's no justice without this experience, however impossible it may be, of aporia. Justice is an experience of the impossible. So this is definitely a claim that Derrida is making here, that in order to have a sense of what justice is, we have to go through the experience of not being able to experience justice, not just to experience injustice, but to experience the difficulty of the concept of justice itself. Um, he maneuvers on into a will or a desire here, a demand for justice whose structure wouldn't be an experience of aporia, would have no chance to be what it is, namely, a call for justice. Every time that something comes to pass or turns out well, every time that we placidly apply a good rule to a particular case, to a correctly subsumed example, according to a determinate judgment, we can be sure that that law or droit may find itself accounted for, but certainly not justice. Law can be enacted in the particular, but law is not the same thing as justice. Law is not justice, as he says. Law is the element of calculation, and it is just that there is be law. It is just that there be law, but justice is incalculable. It requires us to calculate with the incalculable. The operatic experiences are the experiences, as improbable as they are necessary, of justice, that is, to say, of moments in which the decision between just and unjust is never ensured by a rule. And so he comes back to the language of addressing again here, right? And so I must address myself to you. That's the French version, right? And address, in quotes here, problems, address in the transitive English sense, right? Um, I must do it briefly and in a foreign language. To do it briefly, I ought to do it as directly as possible, going straight ahead without detour, without historical alibi, without obliqueness towards you. Supposedly the primary addressees of this discourse, but at the same time toward the place of essential decision for the said problems. Here I am, you're paying me, I'm under contract, I'm talking to an audience of legal scholars. I've got to say something, I'm being paid to say something. When am I going to get to the point, right? Um, address as direction, as rectitude, says something about droit or law or right. And what we must not forget when we want justice, when we want to be just, is the rectitude of the address. Il ne faut pas manquer d'adresse. I must not miss an address. That's the translation, literal, of the French there. I might say in French, he says, but above all, il ne faut pas manquer l'adresse. One mustn't miss the address. One mustn't mistake the address, and the address always turns out to be the singular. Now, he's doing a play on words here. I must not miss the address, like the speech that I'm giving, but I also must not miss the location. I must not drive too far and get lost, and therefore miss the speech that I'm supposed to be giving. Um, uh, One mustn't mistake the address, and the address always turns out to be singular. And so this moment in which I, Derrida, am speaking to my audience is a singular contextualized moment. As I put myself into words in this particular moment, I may be corresponding more to something like law, but the more that direct that I go, the further away we're going to get from justice itself. And that's why I've been hovering so long and drawing us back to the context itself. He's trying to show us through the example of his words what he is talking about in terms of the problem of deconstruction and the possibility of justice. He goes on and says, an address is always singular, idiomatic, and justice as law, droit, seems always to suppose the generality of a rule, a norm, or a universal imperative. How are we to reconcile the act of justice that must always concern singularity, individuals, irreplaceable groups, and lives, the other or myself as other, in a unique situation with rule, norm, value, or the imperative of justice, which necessarily have a general form, even if this generality prescribes a singular application in each case? If I were content to apply a just rule without a spirit of justice and without in some way inventing the rule and the example for each case, I might be protected by law, my action corresponding to objective law, but I would not be just. And here he turns to Immanuel Kant again. And remember, I've said in earlier contextualized readings that Kant is hovering right behind here. Kant's deontological ethics and his categorical imperative is hovering right here. He says, I would act if I was applying the law and maybe I was applying it correctly, I would apply as Kant would say, or I would act as Kant would say, in conformity with duty, but not through duty or out of respect for the law. And in Kant's groundwork for metaphysics of morals, Kant it goes into more detail about this, that it's not just the fact that you did something right and it happened to be right. It has to correspond, like one's will needs to correspond with the metaphysical version of the rightness or the metaphysical version of duty. And so we're always going to mistake things in this world. It's a very Christian way of looking at things, right? And I think that this is Derrida is getting at something very fundamental to the way that Euro-Christian culture works in this particular essay, which I'm digging into very heavily. And that's part of my reason for going really slow here. Because Kant and Euro-Christian culture will create this kind of transcendent God, especially the Protestant Christian God, right? After the Reformation. But Kant is going to say that there is an eternal kind of realm of the analytic forms, and then there, but our experience of justice is always going to be synthetic. It's always going to be the fact that I don't experience the world in itself as it is. In reality, I only experience the world through my embodiment, and not just through my embodiment, but through my intellect and the way that my intellect will take the information that my body brings into itself and create subject and object. So that line up above where he says, the other or myself as other, thinking about myself, that reflective self-consciousness that is so much a part of European modern philosophy from the 16th century onwards, but especially encapsulated by Cartesian thought and Descartes' meditations on first philosophy. He's not the only one to do it, right? I mean, of course, he's drawing on Aquinas, and he's trying to distance himself from Aquinas in the earlier tradition of scholastic thinkers, and so that there's an ongoing discussion in philosophy around these issues. But I think what Derrida has in mind right here is definitely Kant and Descartes through Kant. And so the idea of um, some kind of categorical imperative duty in its most pure sense is not something that we ever have access to, because once we bring it into this particular world, it's the world of uh, um, of of concrete materiality, but also the world that's always changing and corruptible in and of itself. So he goes on, is it ever possible to say an action is not only legal but also just? A person is not only within his rights but also within justice. Such a man or woman is just, a decision is just. Is it ever possible to say, I know that I am just? Although, allow me another detour. And again, so he's going to do the detour, and this is part of his style, right? It's frustrating to those outside of it, but hopefully you're getting from these lectures a sense of why he's doing it. He's putting us into the situation of the impossibility of translation and language, the impossibility of knowing something completely, and the fact that knowing something and grasping something completely uh, is a distortion in some sense of the thing itself. Um, he says to address oneself to the other in the language of the other is, it seems, the condition of all possible justice. But apparently, in all rigor, it is not only impossible, since I cannot speak the language of the other except to the extent that I appropriate it and assimilate it according to the law of an implicit third, but even excluded by justice as law, inasmuch as justice as right seems to imply an element of universality. The appeal to a third party who suspends the unilaterality or singularity of the idioms. It takes justice takes a third. And again, this is right in Emmanuel Levinas's thought that like we can have two people who are battling or in a conflict with each other, and it takes an arbitrator, someone in a different position to adjudicate the issue, right? So justice needs that third perspective, according to Derrida and Levinas here. And it's going to take us out of the singularity of the two idioms. He says, when I address myself to someone in English, it is always an ordeal for me. For my addressee, for you as well, I imagine. Like, I understand this is really confusing and hard and difficult, right? Rather than explain why and lose time in doing so, I begin in medias res, but in the middle of things in Latin there, with several remarks that for me tie to the agonizing gravity of this problem of language, to the question of justice, of the possibility of justice. Um, uh, so again, I have to begin in the middle of things. I have to begin with the problematic space that I'm in, and even trying to address you in English as a native French speaker, and also a Jewish person. That I think that's hovering here, as well as we will eventually get to Walter Benjamin. Uh, um, and the way that Christianity is playing a part here in Christian thinkers like Kant. And that's going to come up on the next page here, especially. He says, first remark, on the one hand, for fundamental reasons, it seems just to us to rendre la justice, as one says in French, in a given idiom, in a language in which all the quote subjects concerned are supposedly competent, that is capable of understanding and interpreting all the subjects, that is, those who establish the laws, those who judge, and those who are judged, witnesses in both the broad and narrow sense, all those who are the guarantors of the exercise of justice, or rather of droit. Now, this use of the word subject is exactly what I was saying about the Cartesian subject, the modern philosophical subject, that in the Euro-Christian worldview is separated from the world, is only mediated through bodily experience that must be translated into thoughts and concepts, right? So Descartes, whether you agree with him or not, we're not going to do a lecture on the meditations right now, but Descartes is trying to prove the existence of God, and he says that the existence of God must come from the fact that I have an idea of the infinite. I have the idea of the eternally good in me. It's a piece of God in me, but I am not able to realize it because I am a finite type of being. That is one of the ways of thinking about this Euro-Christian version of the subject. And it is a self-reflective subject that must understand through self-reflection its place in the world. And by the time we get to Immanuel Kant, its moral place in the world, its place in the relationship of justice and law. And so this is, as we maneuver on here again, uh, Derrida's Jewishness and his Algerian upbringing is going to come into play very quickly as we finish this paragraph. So law, in one sense, if it's going to be enacted, it's necessitated that the subjects are individuals who are self-reflective of understanding not only the language of the fact that they might be being accused for something, but the idioms within that language, and the sense that they might have some sort of moral responsibility. There has to be a recognition of authority. There has to be a recognition of subjectivity and the possibility of having done wrong. So it is unjust, he says, to judge someone who does not understand the language in which the law is inscribed or the judgment pronounced, etc. We could give multiple dramatic examples of violent situations in which a person or group of persons is judged in an idiom they do not understand very well or at all. And however slight or subtle the difference of competence in the mastery of the idiom is here, the violence of an injustice has begun when all the members of a community do not share the same idiom throughout. Think about what's going on in 1989 when this is presented. It's before the European Union. The Berlin Wall has just come down. Here's Derrida in New York giving an address. We've had all sorts of wars, not just World War II, but particularly French war in Algeria. We've been dealing with post-colonialism at this particular moment in not just academic, but in just sort of general Western political and academic history. He says, since in all rigor this ideal situation is never possible, we can perhaps already draw some inferences about what is the title of our conference, The Possibility of Justice. The violence of this injustice that consists in judging those who don't understand the idiom, in which one claims, as one says in French, that justice est faite, justice is done or justice is made, is not just any violence, any injustice. This injustice supposes that the other, the victim of the language's injustice, is capable of a language in general, is man as a speaking animal, in the sense that we, men, give to this word language. Moreover, there was a time not long ago, and not yet over, in which we men, in quotes, meant we adult white male Europeans, carnivorous and capable of sacrifice. He is talking about colonialism here, right? He's invoked colonialism. He's invoked the European or Euro-Christian sense of what makes a human a human. The European legal rights-bearing subject, who knows the law, who's been cultivated, who's been educated. Indigenous people are not part of that thing, right? We could go back, we could look at the requerimiento that the Spanish conquistadors are sailing up and down the coasts and sometimes reading off and speaking out into the jungle, that is in Spanish. So it's not like the indigenous people understood it to begin with, but giving them the legal option to either convert to Christianity or to be held in perpetual slavery or killed, right? If we look at the language of the papal bulls, we look at from the 15th century, or if we look at the language of the requerimiento as well, all the way into the current U.S. legal system through cases like Johnson v. McIntosh in 1823, which brings into U.S. law, it bases U.S. law on its inheritance of the bulls of discovery and the language of discovery from the papal bulls, which is a big part of my other scholarships. I'm not going to go into it too much here today, but I want to say that Derrida is definitely making the possibility for us to think about the longer history of European legal structures and how unjust it would be to try to apply to the law to people who do not understand the law. But the flip side of that was that we got Euro-Christian or Christendom or Christendomination, right? Christendom, like the idea that the Europe and unified Europe, especially after Westphalian peace in 1648, somehow the last Christian peace is the name of a book on the Peace of Westphalia that supposedly ended the Christian wars against each other. It didn't really do that, but created the nation state, and now we have international law and all of that good stuff. But within that, what Derrida is saying is that there has always been and still is an element of injustice that's not only masculinist, we men, it's racist, it's we white men, and we adult white men, so children aren't part of this. And then he adds this other really intriguing element, carnivorous and capable of sacrifice. He maneuvers on in the next few paragraphs to talk about the animal and the human animal extinction, or the human animal distinction. Excuse me. One of the things that I will say characterizes Euro Christian thought as opposed to indigenous thought, and this goes along with my work with my Osage friend, Dr. Tink Tinker, and our book that hopefully is coming out soon. Uh, is that Euro-Christian thought is anthropocentric and androcentric. It seems to see the world only in terms of what it means for human beings, and particularly for um uh it then casts that back out onto the world. It personifies the world in terms of the self-reflected consciousness of this European or Euro-Christian subject. Derrida is gonna, this is gonna be a shift in his thought. He's gonna, one of his last books is gonna be The Animal, Therefore That I Am, right? So this essay is really rich for thinking about Derrida's thought in general. He goes on and he says that the space in which I'm situating these remarks and or reconstituting this discourse would not speak of injustice or violence toward an animal, even less towards a vegetable or a stone. Now, for an indigenous person, for an American Indian, for example, this idea of justice would not work. You cannot have a world without stones, vegetables, animals, all of which have personhood in indigenous worldview, not animism. It's not that they just have a soul that's somewhere inside it. It's not, that's a Euro-Christian idea that the anima is the soul, right? The Latin word for soul. So animism doesn't work for applying to for indigenous folks like American Indians, for example. And Derrida is not, he's maybe a little bit aware of this, but he's not going to take it in that direction. But he is going to critique. He's going to say that there's something missing. If there's something, if we're going to think about the possibility of justice, and we think about the injustice that has been recently done in recent centuries by people who thought that justice only applied to white male Europeans, who are carnivorous and capable of sacrifice, then we need to think to contrast that with what is considered outside of the white male European. So he goes on, he says that an animal can be made to suffer, but we would never say, in a sense considered proper, that it's wronged, it is a wronged subject, the victim of a crime, of a murder, or a rape, or a theft, or of a perjury. And this is true a fortiori, we think, for what we call vegetable or mineral or immediate species like the sponge. Now, we do have in the 21st century, we have a much more robust discourse on animal rights, and definitely philosophers like Singer, for example, who have brought animal rights discourse into more of a mainstream. But is somebody going to take you to court for like breaking rocks with a pick or something like that, right? Or minerals, um, uh, um, or killing a vegetable plant and cooking it, right? And I think that's what Derrida is getting at here. There are still many, quote, subjects among mankind who are not recognized as subjects and who receive this animal treatment. Um, this is the whole unfinished history I've alluded to a moment ago, right? Okay, yes. So this, of course, if we were to think about contemporary Black thinkers who have rejected this European universalized notion of humanity, so someone like Sylvia Wynter, like a Black feminist writer from the Caribbean, she wants to reject the category of human that the Europeans have constructed for themselves here. So rather than trying to fix a flawed system, she's going to say, let's reject the flawed system, right? itself. This is not to say that like we're never going to have justice or law. It's just that justice is impossible if we're thinking of it in that particular system, right? So we have contemporary thinkers who have taken this much further than Derrida is taking it in this particular essay here. Um, he says what we confusedly call animal, the living thing, and as living and nothing else, is not a subject of the law or of law. The opposition between just and unjust has no meaning in this case. As for trials for animals, there have been some, not or lawsuits against those who inflict certain kinds of suffering on animals. So legislation in certain Western countries provides for this and speaks not only of rights of man, but also the rights of animals in general. These are considered to be either archaicisms or still marginal and rare phenomena and not constitutive of our culture. So we may eventually get to someplace where we treat animals better, but we certainly are not in that place right now. In our culture, carnivorous sacrifice is fundamental, dominant, regulated by the highest industrial technology, as is biological experimentation on animals, so vital to our modernity. Um, Definitely, they're ethical thinkers. I'm thinking of my colleague Miguel de la Torre, a Cubano, American theological ethicist who's a vegetarian, and in classes with us would talk about how disgusting meat eaters were. He's a vegetarian. So there are folks who are pushing in that ethical vein. But in general, what would the United States do without beef, right? What would Brazil and Jair Bolsonaro do without, he was trying to cut down the Amazon rainforest to create more pastures to raise cattle and to sell Brazilian steaks. We know that this is highly costly for our planet to raise cattle, and it's expensive, and it is a kind of sacrifice, I think, in the way that Derrida is putting it here. He says, as I've tried to show elsewhere, carnivorous sacrifice is essential to the structure of subjectivity, which is also to say, to the founding of the intentional subject and to the founding, if not of the law, at least of law or droit. The difference between the law and law, justice and law, justice and the law, here remaining open over an abyss. Now, when he says, I've looked at this elsewhere, he's referring to some essays on Walter Benjamin and Martin Heidegger. If you look at his note there, it's note, what, 14 and in this essay, if you looked at, or note, or, it's note number 4 here. This is a bigger discussion. And if we just flip, let me just flip back to the end of the essay here to note number 4, because I was thinking of note number 14. In note number 4, he says that he has taken this up, the very polyhedric and polysemic question of representation is posed as well as from another viewpoint or point of view in this strange essay, having begun by distinguishing between two sorts of violence, founding violence and conserving violence. Benjamin must concede at one moment that one cannot be so radically heterogeneous to the other, since the violence called founding violence, is sometimes represented by the conserving violence. And so this is going to take us, like, remember, this essay, it's 2 talks because he doesn't get to finish it. And at the end, he's talking about Walter Benjamin's essay on violence. And so he's looking, the note is saying that he's looking ahead here, but he's already written about it. And he's done other work, of course, on Heidegger and Benjamin as well. So I think this is deep thinking to think about whether or not, you know, Western civilization, as we might know it, or so-called Western civilization, is somehow founded on carnivorous sacrifice. He says, I'm going to leave these problems aside for the moment, along with the affinity between carnivorous sacrifice at the basis of our culture and our laws, and all the cannibalism, symbolic or not, that structure the intersubjectivity in nursing, love, mourning, and in truth, in all symbolic or linguistic appropriations. If we wish to speak of injustice, of violence, and of a lack of respect towards what we still so confusedly call animals, the question is more topical than ever. And so I include in it, in the name of deconstruction, a set of questions on carnophallogocentrism. We must reconsider in its totality the metaphysico-anthropocentric axiomatic that dominates in the West the thought of the just and the unjust. I'm going to pause there and think about, I've contextualized this as the West against indigenous peoples, for example. We could talk about indigenous peoples of Africa. I'm less familiar with indigenous peoples of Africa, but I am more familiar with indigenous peoples of where I live. So American Indian perspectives, which would agree, I think, very much with Derrida here. I think they would push Derrida even further than he's going. But what Derrida is giving as his answer to deconstruction, the possibility of justice, is first that if we really want to think about justice itself with a capital J, we need to understand that justice is both deconstructible, but deconstruction is a kind of justice. Though if we're going to see that justice is deconstructible, then the thing that we have put in place firmly as justice in Western civilization is something that is a kind of false god, if you to take a very Western theological kind of perspective, that it is an instance or a body of laws is a set of instances that an individual subject may be subjected to, may be experienced of, but one must experience to really experience what justice is. One must experience the fact that justice can't be completely gotten at through through particular kinds of instances. And not only that, like if we're going to think about justice, we need to think about its communicability, not only from a French speaker to an English speaker, but to somebody who doesn't speak any languages in common, of these two European groups who have had a long and violent history between the English and the French, right? Or what about a language that isn't familially related? Like I don't know, Diné or Navajo language, for example, right? Totally different kind of language, totally different way of conceiving things. Lakota being another one, Washaje or Osage. So when we do that, when we take a more modest view of so-called Western civilization and the way that justice was only applied to people who were either adult white male Europeans or who had some way achieved the symbolic status that white male adult Europeans have, um, uh, then we have to that justice system is the thing that kind of needs to be undone, in the sense of an aporia. It doesn't mean undone in the sense of like, let's just blow it all up. That doesn't seem to be what Derrida is saying here, but it needs to be seen for the problem that it is, the problems that it is invoked, and the injustices that it is invoked throughout the world. And in that sense, it must be completely rethought from all the way back to Aristotle, thinking that, of course, like the way he defines barbarians, or like Greek citizens are the like citizens are people, adult males who speak Greek, right? Like had to in order to be full citizens in the polis. Or we could look at citizenship in Roman terms, especially because the Roman Empire expanded into other places as well. That's taking us. I've been talking for a while, so I think that this is good for a contextualized reading for today. We will pick up again later on page 19 of the text. Thanks for your attention and for reading and thinking alongside me with this fascinating essay. Hope you do well, you're doing well, and that you have a good morning, evening, afternoon, whenever, wherever you are. Support us on Patreon or somewhere else if you can, and if you are able to. Thank you.